Time.
This is LBC News.
I just want to check back on a story we did a couple of weeks ago, and it's one that's running now because possibly the biggest mis-selling scandal involving the buying of motor cars, cars, lorries, vans, whatever it might be, and the finance that you and I probably use in getting a PHP, PCP, whatever they're called, these kind of schemes. A huge proportion of new cars are sold with these schemes, and it appears that there has been some mis-selling, if that's the right word to use, in terms of the conversations that existed between the dealers who were offering you this finance and the banks and financial institutions that were funding it. Sam Ward is a chief investigator and director at Sentinel Legal, a company that is looking into this. The scale of how serious this has a problem this is, Sam, is it's a moving target, this one, isn't it? What's your latest thinking on this?
It really is. I mean, when the FCA first came out and banned the discretionary commission model in March 2021, I don't think anyone really appreciated how big of a deal this was going to be. And to be honest, Martin, how big of a scandal it's actually turning out to be. During the time from sort of 2021 and to now, Sentinel Legal's investigations, we've uncovered that in actual fact, the discretionary element which the FCA originally banned is just really the tip of the iceberg.
Right. And let's just, for people who maybe you're not familiar with the story, I go into my local dealership, I say, OK, I'll take a new one of those, and you can sort out some payments. It's going to be £599 a month over the next 3 years. There's a balloon payment, blah, blah, blah. But that $599 I'm paying may well have been artificially elevated. Now, just remind us how.
Yeah, for sure. So the way it works, the general public would walk into a car dealership and they would expect that car dealer to be earning their profit, their money from selling you the physical vehicle. Now, what's actually transpired in a lot of cases, the dealerships were selling the cars at a loss or a cheaper rate than advertised if you was a cash buyer, so that they could force you down a finance route, which would result in very, very big commissions. And just to give you a size of the mis-sell here, Martin, we had one particular client who had walked into his local Land Rover dealership. He took out finance on a new Land Rover. The total amount of finance was £81,000, and the total commission that was paid from the finance provider, in this case it was Santander, to that dealership, that Land Rover dealership, was £16,049.
Good grief.
Yeah.
So if that payment didn't exist, the car could have gone to the customer for a whole much cheaper. Or more to the point, I suppose, that the customer was not aware that was going on in the background.
Yeah, this is the big problem, and this is what the Court of Appeal came out in October and unanimously decided that was unfair and is now illegal. The fact that the consumer was never given informed consent. So the dealer never told the consumer, the buyer of the car, that they had a relationship with the car finance lender, that they would be incentivized to pass that particular lender the vast majority of the finance agreements, and that they would get preferential interest rates and preferential commission rates in order to keep that what was kind of a quasi-exclusivity agreement
out of the public eye. Yeah, away from us. Where are we on the stage of, OK, you've made a misstep here. Are you going to admit it? Are you going to give customers some money back? Where are we with that?
Well, we're about 4 weeks away from the Supreme Court hearing this now, Martin. So the Supreme Court are hearing this on the 1st, 2nd and 3rd of April, and they will be the final say. So the arguments will be presented from the banks. The claimant obviously has already won in the Court of Appeal, so they will be further expanding on the reason for the mis-sell and why it is unfair in the biggest court in the country, which is the Supreme Court. So once the Supreme Court has concluded, we'll probably hear their decision. Hopefully, we're all hopeful that it will come before summer, which will give consumers that have been mis-sold the much needed clarity on what's happened and more importantly, how they can recover compensation.
How can they make an appeal to come back on that? Okay. And we're noticing this, the banks are taking this seriously, and the direction of travel is quite clear, because they are making provision in their annual accounts, aren't they, that we are probably going to have to pay out hundreds of millions of pounds here.
Yeah, exactly. So I don't think any of the banks that are on the hook, so Lloyds, which own Black Horse, which is one of the major car finance providers, but you've also got Santander, Clydesdale Finance, which is part of Barclays. Every single one of them have come out and made their provisions. I think the total amount that's been made available by the banks so far is around £2 billion.
Right.
With Lloyds being the biggest at about 1.15 billion set aside for this level of compensation. And that's before the Supreme Court have made their decision, Martin. So we can only assume, learning the lessons from PPI and Plevin, which was the biggest financial scandal the UK has seen so far, that it will only increase as PPI and Plevin did, and ultimately they ended up at about 53 billion in compensation paid. So who knows where this will land.
Sam Ward, thank you very much indeed for updating us. Chief Investigator and Director of Sentinel Legal. And as Sam was saying, that will go to the Supreme Court, and I'm sure we'll report on that case when we reach a decision. OK, we're going to go back to the House of